Theft and vandalism are criminal acts. Criminal acts are the actions which are judged unacceptable in our society and which go against our fundamental values. Criminal acts have their basis in criminal law, which is determined by the federal government. Indigenous peoples and the non-Indigenous are subject to the same rules. An act considered as criminal for a non-Indigenous person is also considered as such for an Indigenous person, whether it happens in the community or in the city. The judicial procedure is also the same. Nevertheless, at the moment of determining the appropriate sentencing for an Indigenous person recognized as guilty, the judge will consider the criteria established in the GLADU report. Vandalism is the act of intentionally breaking, destroying, or damaging the property of another person. Vandalism is committed if you scribble graffiti on the walls of your school, you throw rocks at the windows, you pierce the tires of a car, you engrave your name on your desk. In criminal law, vandalism is called mischief. Stealing is defined as taking something that does not belong to you without having the right to do so. In other words, without having received authorization. It is a matter of having deprived the owner of his property, having removed what is rightfully his. A theft is committed if you leave with the knapsack of another student, in the store you slip merchandise into your pockets, even if it is of little value, shoplifting is theft. You take the computer left alone on a desk and keep it in your locker. You borrow the coat of another person without his permission. A theft is committed even if you don't hide yourself to do it, you take the object with the intention of putting it back. After having removed the object, you decide to put it back in its place. You were just playing a joke. We sometimes hear the term aggravated theft, but what do we mean by the term aggravated? Aggravated theft is a theft during which there is use of violence or threat to use it. It can also consist of a theft where a weapon is used. An aggravated theft is committed even if you use a fake weapon, an imitation, or a toy, for example. You pretend to have a weapon. The punishment imposed upon an Indigenous person for aggravated theft varies in relation to the seriousness of the theft and the violence used. In other words, the judge will assess the value of the stolen goods, whether or not a weapon was used, whether injuries were inflicted on a person, and the criteria established in the GLADU report. An adolescent is held criminally responsible for his acts as soon as he reaches the age of 12. In the justice system, youth aged from 12 to 17 are called minors, and distinction exists between the criminal justice system applicable to adults and that for minors. The criminal code regulates the procedure and sentencing which applies to adults, while the Youth Criminal Justice Act establishes what is applicable to minors. Within the framework of this law, minors can benefit from extrajudicial measures and sanctions. They permit avoiding a court trial for the adolescent. Among the measures, instead of undergoing a trial, an adolescent can benefit from a police warning, from a referral to a social skills development program, from mediation with the victim, from community work. Despite the existence of these extrajudicial measures and sanctions, a minor can still be subject to a trial before a judge and be declared guilty of an offense when the crime and the situation warrant it. At the moment of the arrest by a police officer, a minor has the right, as do adults, to know why he's being arrested, remain silent, speak to a lawyer. But contrary to adults, a minor has the right to be accompanied by a parent during questioning. His identity is also kept secret. His file remains confidential. But who has the right to arrest you on community territory? As a general rule, the communities are served by Indigenous police forces, and in the cases where the community is not equipped with a police force, it is the Quebec Provincial Police which patrols and intervenes in the communities. The Police Act allows Indigenous communities to establish their own Indigenous police forces. The Indigenous police forces are mandated with keeping the peace and order over their territory. Meanwhile, even if the community has its own police force, the Quebec Provincial Police can continue to intervene on the reserve. In comparison to the Quebec Provincial Police officers, what can the Indigenous police officers do? These police officers can patrol in the community, investigate, take preventive actions, arrest people, deliver fines, answer to emergency calls from members of their community.